promise I won't speak for as long as Ms. Bernstein-Lev or Mr. Avila, so I'll get you out of here as soon as possible. Now, as Ms. Bernstein-Lev gives her closing argument, I want to remind you, jurors, that during opening statement, when Mr. Frenzel gave his opening statement, he gave a pretty different story of what you were going to hear during this trial. He stated that during this case,
our opening statement is not evidence.
Overruled. Counsel, you may continue.
like I said, during his opening statement, he stated that the defendant went over to Amie's house with the intent to kill himself. And that when a struggle ensued, Amie, on her own volition, climbed over a 3.5-foot balcony and fell to her death. Now, you heard a different story here by Ms. Bernstein-Lev. And that story is that the defendant just...
I'm going to object to the reference to suicide based on the court's prior rulings.
Well, no, I think it cuts both ways. I'm going to allow counsel to continue.
Now, in this instance, when Ms. Bernstein-Lev gave her argument, you heard something different. She said that the defendant went to Amie's house out of a sense of desperation just to talk to her. And that it was Amie that physically initiated an aggressive struggle between the two of them, and that she climbed over the balcony and fell to her death. Now, what's important to note about these different versions of events that each of the defense attorneys has presented to you is that it's a story. That's all it is. A story concocted by the defense that has absolutely no basis in fact. Or repeat that again. Like I said, the different version of events the defense is giving you is simply that, a story. A story concocted by the defense with absolutely no basis in fact.
That's improper argument.
And absolutely no...
Concocted by the defense is improper argument.
Well, you may take it as such, but in so many words, the prosecution's version of what occurred, I think, was also attacked by the defense in their closing. So you may continue.
I'm going to try to finish my sentence one more time. Each version of the events the defense attorneys have given you is simply a story. A story concocted by the defense that has absolutely no basis in fact, nor is it supported by the evidence. Now, members of the jury, as jurors in this case, it's up to you to decide what happened in this case. You decide the facts based on the witnesses that you heard, based on the evidence that's been admitted, and based on what you heard throughout this entire trial. And then it's also your job to apply the law to the facts that you've determined. Now, I tell you that the evidence that you've heard throughout this trial establishes the prosecution's theory of this case. And that is that the defendant came to Amie's house with the intent to kill her when he brought that loaded syringe with a lethal dose of nicotine, that he broke into her home, that he took her by surprise, beat her up, strangled her, and then dropped her over the balcony to her death. That's what the evidence establishes in this case. Unlike what the defense told you, it's not a story. It's based in fact, it's based on evidence. Now, I told you about your duty as jurors to determine what happened in this case and how to apply the law. But there's something else that I want you guys to think about when you go back into the deliberation room, and just some pitfalls that I want to warn you about. And that is wanting more. I think I touched on this in voir dire just a little bit. We talked about that burglary analogy I used of the car. But it's natural. As human beings, we always want to know more. More background, more witnesses, more police reports. Even though it's natural to think that way, you have to base your decision and deliberation process on what you heard in trial with actual evidence. Jurors tend to play this what if thing. What if Amie arrived at the hospital earlier? What if there were more nest videos? What if the defendant changed his mind? I mean, these questions were specifically answered in trial, right? Dr. Luzzi said if Amie was right outside of the OR, probably wouldn't have made a difference. If there were more nest videos, we didn't have any. The police did everything they could to get all the nest videos that Ms. Harwick possessed. And based on the defendant's conduct before during and after the murder, he never changed his mind. But nonetheless, don't engage in that what if game. Don't speculate. And we'll get to this later on in my argument, but that is exactly what Ms. Bernstein-Lev is having you do. Speculate, 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 based on misstatements on the law and misstatement of the evidence that you heard in actual trial. Don't make it personal. We all come from different backgrounds. We all have different unique experiences. And I think there's a tendency to think, if I were the victim, I would have done this. If I were the defendant, I would have done this. I caution you from doing that. Instead, again, listen to the evidence and base your decision on the evidence you heard in trial. Refusing to deliberate with other jurors. Now again, you can only come to a decision if all of you agree. So remember, this is a collaborative process. Now, I don't think that none of you or any of you would decide to not deliberate or get along, but remember to keep an open mind and respect each other's opinions. Using the possible doubt standard. Look, you can have some doubt about non-issues in this case. Again, there's always going to be unanswered questions. But do not hold us, Mr. Avila and I, to an impossible burden. Do not hold us to a burden that's beyond a shadow of doubt, beyond any imaginary doubt, because as the jury instructions specifically say, anything in life is subject to some possible or imaginary doubt. The standard of proof in this case is beyond a reasonable doubt. Verdict forms. They can be confusing, so I'm just going to touch on it really quick. It's just, if you find the defendant is guilty of burglary, you fill out that verdict form. You then have to decide whether or not there was a person present. If you find the defendant guilty of first-degree murder, you fill out that verdict form. And then you must determine whether or not the special circumstance of lying in wait is true or not true. Voluntary manslaughter, heat of passion. Now, there were some misstatements about what the law actually states in Ms. Bernstein-Lev's argument. So I'm going to go through this very carefully. The elements of this crime, the heat of passion, or a killing done in the heat of passion, is the following. 1, the defendant was provoked. 2, as a result of the provocation, the defendant acted rashly and under the influence of intense emotion that obscured his judgment. 3, that the provocation would have caused a person of average disposition to act rashly and without deliberation, that is from passion rather than judgment. Some key points I want to point out to you in regards to this specific jury instruction. While there's no specific type of provocation required, slight or remote provocation is not sufficient. Not sufficient. The defendant is not allowed to set up his own standard of conduct. Consider whether a person of average disposition in the same position, knowing the same facts, would have reacted from passion rather than from judgment. That being said, I'm going to give you examples of what is not voluntary manslaughter, or what is not provocation. It's not enough that a person is mad. It's not enough that a person is upset. It's not enough that a person is desperate. It's not enough that a person is sad. Or it is not an argument or a fight that went bad. That is not provocation. So there has to be some sort of trigger, a provoking act, and that provocation would have caused a person of average disposition to act rashly and without due deliberation, that is from passion rather than from judgment. And don't let the defense confuse you with the use of the word passion. Just because Ms. Bernstein-Lev used that word repeatedly doesn't mean you adopt the meaning that Ms. Bernstein-Lev is giving you. There is a legal meaning that qualifies as passion under the law. Now I want to talk to you a little bit about just this tenet of killing in the heat of passion. It's an incredibly important part of our law. It allows for the mitigation of the killing of one human being based on heat of passion. I'll give you an example. let's say, walk in on your child being sexually assaulted and that person is killed. Another instance, someone discovers that an immediate family member was just murdered and that person kills the perpetrator. Now, in those specific situations, any normal person of average and normal disposition would be so overwhelmed with emotion, so overcome by anger and passion, that it would drive that person to use deadly force and kill. That's what we're talking about when we talk about a killing done in the heat of passion. Let me tell you what's not an example of a heat of passion killing. Let's say there's a man who runs into someone who ridiculed him and mocked him for years in high school, making his life a living hell. And he runs into him years later and decides to kill him. Now that killing was done out of a desire to get back at that guy for the years of torment. That was a killing done out of revenge. That is not a heat of passion killing. That is not voluntary manslaughter. Now, similar in this case, you have the defendant who is now claiming that he was provoked by Amie and that he killed her out of the heat of passion. The defendant, after running into her, after breaking up with her, or the relationship ending nearly 9 years prior, and running into her at the Eggs Fizz Awards, he then kills her a month later. That is not a heat of passion killing. Like I said, he can't now claim that Amie provoked him when he's the one that broke into her home, when he's the one who provoked a physical struggle between himself and the victim. It does not justify him going to her house, uninvited, breaking in, beating her, strangling her, and then tossing her over a balcony. That is not justified under the law. That is not heat of passion as defined by the law. Now I want to talk to you about assuming, just for argument's sake, just for a second, that we believe the defense's argument. That we believe, you know what? Amie was a person who was initially aggressive for the defendant. Let's just pretend that that's what happened for 1 second, okay? Well, if that's the case, Amie was perfectly within her right to defend herself in her own home, especially when you take into account her state of mind at the time of this incident. Specifically when you consider what happened at the Eggs Fizz Awards between the defendant and Amie. This email, which has been shown by both Mr. Avila and Ms. Bernstein, so I'm going to go through it really quickly, really goes to show not just what happened at the Eggs Fizz Awards, but how it truly made Amie feel. Now, Ms. Lev came up here and talked about this email, and she entirely focused this email as to, again, how the defendant feels. How he must have been feeling when he saw Amie. But this email was written by Amie. Not only does it talk about her fear, but it talks about just how angry, not desperate, angry the defendant was at the Eggs Fizz Awards. She starts the email with, "Tonight I felt very scared." That is the first thing she types up in that email when she comes home later that morning from the Eggs Fizz Awards. He says, "Gareth came up behind me and started screaming, 'Why are you here?' He looked dysregulated and his eyes looked out of control. He started screaming, 'You don't even like porn, you shouldn't be here. Why are you here?' He looked like he was going to cry. He was breathing heavily, flailing his arms around. I didn't want to make a scene or scare anybody else." She goes on. "We sat close by the bathrooms. I made sure to look and make sure there were both security people and a lot of attendees very close by." She was so scared, even at the Eggs Fizz Awards, that when she pulled him aside, she wanted to make sure she was around other people and security guards. "I was scared and felt like I needed to neutralize the situation. I mean, Amie's a wonderful person. Her ex-boyfriend from nearly 9 years prior to that, is screaming at her, and she takes it upon herself to try to calm him down and neutralize the situation. He told me he lost his job. Continues on. What's important to note here in the second sentence is he couldn't stop obsessing over me. He recited text messages that I sent from this time frame about 9 years ago. Recited the date, who they were to, and exactly what they said, word for word. I couldn't believe it. Again, I was very scared. She ends the email. I'm pretty nervous that I'm more on his radar now. It terrifies me that he's obsessed with me for 9 years. He thinks about me every day, can't move on, cries, and despite what Miss Bernstein said about Fernando Chavez making up the word tantrum, she says it in her own email, and throws tantrums in this way. He's focused on harming me. I'm hoping that this interaction and listening and giving him time may cause a neutralization in his anger towards me. Now, you don't have to just take Amie's word for what happened at the Ex-Biz Awards. You can take a look at Hernando Chavez's testimony, as well as Aspen Jamieson. Remember, Aspen Jamieson has no stake in the game. She doesn't know the victim. She doesn't know the defendant. They both came in here and testified. Dr. Chavez said, "You ruined my life, you bitch." He heard the defendant say that. Ms. Jamieson, again, who has zero stake in the game, isn't friends with either of the parties involved, says she heard something to the effect of, "You fucking ruined my life." And if you recall her testimony, she stated that she heard the defendant not only screaming at her, but cursing at her. So that anger was definitely apparent. Now, like I said, this encounter at the Ex-Biz Awards wasn't just a display of the defendant's anger, but really it demonstrated just how terrified Amie was of the defendant. And we know this based upon other things. Not only did the encounter at the Ex-Biz Awards scare Amie, but so did the repeated attempts by the defendant to contact her the very next day after the Ex-Biz Awards, where the defendant admits to looking up her phone number and finding her. He then texts her. Amie, being nice, tries to neutralize the situation as she did at the awards, says, "I'm glad we had a chance to speak. Sounds like we both need to express and hear some things from the other person." The defendant goes on to say, "Not sure if you're done, because you said, how do we finish this now last night? But if we can meet again." He wants to see her again. And how does Amie react? Amie, again, takes a very neutral position in trying to calm the defendant down. I think it was really good that we were able to speak last night. I'm sure there's a lot more that you want to process and say to me, but I think that was a lot for both of us. I hope you were able to hear me last night when I said that I was sorry for anything that caused you suffering, and that I forgive you for the things that you did to me. I think right now it's best to have some space, and I don't mean that in a negative way. The past is sad and triggering for both of us. I think we ended our talk last night well. We can be civil from a distance, respect each other, and move forward with our own lives. You know, Amie politely tells him that she doesn't want to communicate with him anymore, that she doesn't want him back in her life. But the defendant doesn't take a hint. He doesn't take no for an answer. He, again, texts her 2 hours later. This tirade, "So you're still gone," which is exactly my nightmare. It's sadly what I expected. So on and so forth. We saw this text message earlier, so I'm not going to reread it. He goes on again, further to text her. "I don't know how busy you are, and it truly scares me so much more than I could possibly convey to say this. Please don't just vanish on me. Please, please, don't let me go through that again." Again, reaching out to her, begging for her to be back in his life. No response by Amie. Again, he texts her almost 5 hours later, please call me. Again, no response by Amie. The next day, he even leaves a voicemail for Amie. Again, also, Amie decides not to respond. She's done. She wants no more contact with the defendant. And this repeated effort by the defendant to reach out to her only further scares her more. And you know this from all of the conversations she had with her friends. She tells Renato Chavez that Gareth found her number online and messaged her. She says, I told him I didn't want to talk and wished him the best, but his response was still obsessive and scary. She talks about a handyman coming in to put more locks on the windows and that she actually got pepper spray. She said that he sounds unstable because he keeps texting her. She talks to Robert Koshler, who she also describes to him about running into the defendant at the ex-Biz Awards, about how he acted really crazy and how he's obsessed with her. She ends the text message by saying, I took safety measures today, or realistically scared for my safety. My anxiety isn't bad now, I just realistically think something could happen to me. During her dinner and walk with Sarah Rollins, she specifically tells her, and you heard her testify, that Amie was scared of what he might do to harm her or her clients. She texts Marcy Mendoza, I had to block Gareth. He continues to message me after I told him I did not want to have contact. He even said that you sent your psychic energy to control the Star Trek episode that he's watching that reminded him of me. This is really scary. Do you notice the word scary or the word scared? How many times has Amie used that to describe the defendant's conduct? To Grace Stanley, I'm more concerned about my safety right now with Gareth's situation. I blocked him through text message, but because of his level of obsession, and I definitely don't think I'm in the clear. I have pepper spray at the house now. My roommate is on alert. I'm upping my home security cameras. So what do you take from all of this? Okay? If we assume that the argument that defense counsel is posing to you, that Amie was initially aggressive with the defendant when she ran into him into her house, at her house, she was deathly afraid of the defendant at this time. So it's no shock that she was unhappy to see him when she goes up the stairs and sees him waiting in this dark TV media room for her and takes her by surprise. She made very clear that she wanted nothing to do with him, didn't want to see him, and wanted absolutely no contact with him. And she's terrified of him. And that's what she sees when she comes home at around 1 in the morning on Valentine's Day, to see the defendant, 6'4", 230, fit and buff, standing or sitting or waiting for her in that dark TV media room. How do you think she's going to react? She's absolutely entitled to defend herself in her own home. The defendant's obsession with Amie does not justify his actions. His renewed anger towards her when seeing her at the ex-Biz Awards doesn't justify his actions. And this intense desire to have Amie back in his life also doesn't justify his actions. Now, members of the jury, I want to talk to you about heat of passion in this last sentence here. Is that based on everything I told you, the defendant can't now claim that he killed Amie in a heat of passion, and that Amie provoked him. He cannot create his own standard of conduct. But when it was him that broke in her home, took her by surprise, beat her up, strangled her, and then killed her. That is not how the law of voluntary manslaughter works. I want to talk to you about provocation. Now, provocation can indeed reduce murder from first degree to second degree. But in this instance, the evidence establishes that there's no provocation in this case. Now, I discussed provocation in the context of voluntary manslaughter, but now I want to talk about provocation in the context of the crime of murder. And there's just simply no provocation in this instance. In fact, the evidence establishes that not only was there no provocation, but the defendant acted with intent to kill Amie, and he did so with premeditation and deliberation. So there can't be provocation here. The defendant planned this. He prepared for this. He intended to kill her all along. Now, the defense will have you believe, again, that Amie, on her own volition, climbed over this balcony to get away from the defendant. And during trial, they alluded to some damage on the awning, that perhaps she tried to reach underneath that awning to leverage herself and scale down from a third-story building. Look, you've heard a lot of things about Amie in this trial. She's smart, she's intelligent, she's beautiful, she's a therapist, she has her PhD, she's admittedly fit and athletic. But what you didn't hear is that Amie Harwick is Spider-Man. Okay, and I say this not to be funny, but because that's exactly what the defense will have you believe. They will have you believe that she climbed over this balcony to get away from the defendant and scaled down her third-story house. That's what they'll have you believe. Not only is that nonsensical, but it's completely unreasonable. And in the words of Ms. Bernstein-Lev, that's what's ludicrous. And I'll tell you why. If she was trying to scale down her building, her balcony, hanging from it, reaching her feet under there, well, she would have fallen in a completely different way. Okay? And we heard from Dr. Luzzi's injuries that Amie Harwick had. She had injuries to her head. And the one injury to her head that's important is that she had a subdural hemorrhage on the right side of her head. She had a fracture to her scapula. Her pelvis was shattered, causing the severe liver lacerations and internal injuries to her kidney. That means she fell onto her pelvis and then onto her right side. Now, she also had injuries to her face. Irrespective of the nasal fracture that Dr. Luzzi saw on her face, she also had other injuries that were evidence of her being beat up by the defendant. Injuries around her facial area, which is marked by the diagram on the left, as well as injuries to her hands and arms, which are also documented on the diagram to the right, which are admitted into evidence. Now, if she had fallen from hanging from the balcony, perhaps to break or fall with her hands, you would have seen fractures or completely different set of injuries to her hands and arms. If she landed on her feet, she would have had injuries to her legs, fractures to her legs, fractures to her feet. If she fell face first, you would have had a wide pattern of injuries, like the subdural hemorrhage that Dr. Luzzi talked about on the stand. Her injuries themselves do not support the contention that she was trying to get down from the balcony and happened to fall. Now, another reason why this is a completely nonsensical, sort of ludicrous version of events is, think about it. You heard how Michael Herman, when he heard the struggle, yelled out, "Hey, motherfucker." Now, you heard also from Dr. Luzzi that due to the strikes that she had to the head, due to the strangulation based on both the internal and external examination of Amie Harwick, it was likely that she was unconscious. It only takes 15 or 20 seconds to render someone unconscious from strangling them. And Ms. Bernstein-Lev can try to undermine the strangulation issue with Michael Herman as much as she wants. The fact that she was strangled is not based on just what Michael Herman heard about choking. And there is a misstatement by Ms. Bernstein-Lev during her closing argument. That is not the first time that Michael Herman talked about hearing Amie Harwick being choked. In fact, he called detectives on February 17th saying, I remember more. And when they interview him on February 20th, he talks about how he heard Amie being choked. And he testified at preliminary hearing that he heard that Amie was being choked. And you heard that during redirect by Mr. Avila during trial. But irrespective of what Michael Herman had to say, we know she was strangled because of the autopsy photos that you saw, because of the testimony that Dr. Luzzi talked about. And he talked about that she was either unconscious or in such a weakened state because of her energy being expended after being strangled by the defendant. So is the defense saying that after being unconscious or in a weakened state, Amie thought to herself, you know what? The best way to get away from this guy is to jump over or climb over the balcony and scale down the building like Spider-Man, or run towards the stairs towards my screaming roommate to get away from the defendant. It just doesn't make sense that someone who is either unconscious or in such a weak state would choose to go over the balcony and scale the building versus running downstairs towards her screaming roommate towards help. It just does not make sense. Now, I talked about how there's no provocation in this case, and that the defendant acted with premeditation and deliberation when he intended to kill Amie Harwick. And we know this based on his actions. It makes it apparent that he was planning to commit this murder, and that on the night of February 14th, 2020, he took deliberate steps to carry out this very murder. The first is we know that he went from his house in Cabora Street, Playa del Rey, to Amie's home in the Hollywood Hills. That's what, 16 miles. In LA, I don't know, 20, 30 minutes to get there. And that whole time, he never turned around. He never thought, you know what, this is a really bad idea. I'm just gonna stay home on Valentine's Day. No, in that 20 minutes, he makes the affirmative decision that I'm gonna go and kill, I'm on a mission. I'm gonna go and kill Amie Harwick. When he gets there, he doesn't park in front of Amie's house. I mean, if you just wanna talk to her, why don't you just park in front of her house, right? No, he decides to park somewhere around Ivar Street and Vine. And instead of just walking to the front door like a normal person, or wait for her outside, he climbs up this hill behind Amie's neighbor's house to access Amie's house. Now let's just pause for a moment. How does the defendant even know where Amie lives? How does he know that by climbing up this hill, he's going to be able to get into Amie's house? That's because he had to do his own independent research and figure out not only where she lived, but the access points to her house, the neighboring properties, and the neighboring streets. That is preparation. That is planning for a murder. In addition to climbing up this hill, he goes and lands here, the neighbor's landing. And when doing that, I mean, he's dressed for this mission. He's dressed to kill. He's wearing a hat to cover his head. He's wearing gloves. He has that rope or string tied around his shorts. And on his person, he's carrying that syringe loaded with a lethal dose of nicotine. Now, why wear these items, right? The hat, obviously, to cover your head. The string around his waist. I mean, they found those shorts or something that looks like those shorts at the defendant's house. And those shorts already have like a black drawstring inside. So we know it's not wearing that to keep his pants up. That's a tool that he wanted to use in implementing the murder, whether that be to tie Amie up, use it to strangle her, what have you. And the gloves. Why would anybody wear gloves? If you want to talk to Amie, why are you wearing gloves? What's the purpose of that? It's clearly not a very cold night. He's wearing shorts out late at night or in the middle of the night. Why are you wearing gloves? It's so that you don't leave your fingerprints behind. It's so you don't leave your DNA behind. So you don't leave any trace of yourself behind so that you can be ID'd later in a crime that you just committed. All of this is preparation. Let's talk about the syringe. Now, according to defense, he just brought this syringe for some other purpose. It wasn't to kill Amie Harwick, it was for something else. But members of the jury, let's straighten something out right now about some misstatements that Ms. Bernstein-Lev said. This is not a syringe the defendant possessed for months and years as evidenced by the color. And according to the testimony, it was very specific. Dr. Maureen Bradley's testimony, which was read into the record, as well as Dr. Benowitz's testimony, talks about that the color may change when there's exposure to the elements. Things like being out on a balcony because of the exposure to the air, or just simply being stored in a syringe can affect the color of nicotine. But the breakdown which Ms. Bernstein-Lev talks to you about is something different. The breakdown of nicotine outside of the body can take years. It can take months. Now, if that's true, well, that's not true in this case because we heard from Dr. Wu, who tested this syringe over a year after this crime happened in July of 2022. That syringe still contained about 87% nicotine. That was the purity level of this specific syringe. And as that Dr. Benowitz testified, that is a lethal dose of nicotine in that syringe. Now, why bring that? You know, Ms. Bernstein-Lev's correct. This is not like a typical weapon you see when murders are committed. It's not a gun, it's not a knife, but it is a weapon of choice by the defendant and it was chosen on purpose. Now, he had to do some work. He had to do his due diligence in determining this weapon, right? He was able to do his due diligence and find out that how much of nicotine would needed to be used in order to kill someone. How would you administer it? You know, how much do you need of this substance to actually be able to kill someone? He had to find out all of those questions before arming himself with this weapon. And in conducting this due diligence, he was able to even determine that this poison of choice that he used is undetected by ordinary laboratories from local law enforcement, that it needs special testing to be detected in someone's bloodstream or in someone's body. And contrary to what Ms. Bernstein-Lev says, you don't have to inject this to kill someone intravenously. You could do it intramuscular, through intramuscular, meaning you could poke anybody, anywhere in their body for them to die from this lethal dose of nicotine. It doesn't have to be directly into the bloodstream. So why bring this? The intent here is to kill Amie Harwick with it. When you look at the syringe, as well as all of the other steps of preparation the defendant took, it goes to show his intent to kill, and he did it with premeditation and deliberation. What else? He covers the cameras when he gets to the landing. 2 different cameras for 10 seconds to stop the recording, stop the motion of those cameras from capturing him. Now, if you just want to talk to someone, why do you care whether your identification shows up in somebody else's cameras? That doesn't make any sense. If he didn't intend to kill Amie Harwick or had no ill intent towards her, then why do this? And then he climbs that chain link fence and then breaks into Amie's house. If he wants to talk to her, why do you have to break into her house? Wait outside, leave her a note. Send her another 5 text messages and voicemails. Why break into her home? Then he breaks into her home, goes upstairs, where he's lying in wait for nearly 4 hours till Amie gets home. And remember, the defendant is 6'4", 230, and pretty muscular and a fit guy, and he's waiting for her in her home in the dark. This is a picture from the body-worn video of Officer Fissick, and that's how it looked when they arrived. So he's waiting in the dark for her. I mean, I watched Monday Night Football last night, and that takes, what, about 3 or 4 hours? So he was waiting just as long as it took me to watch a football game, including timeouts and TV commercials. That's how long he was waiting for her before he killed her. And in those 4 hours, the defendant never decided to change his mind. He didn't decide to go home and say, this is a really bad idea. He didn't decide to go outside, wait on the curb for her. None of that. He stayed upstairs on the 3rd story of Amie's home till she came home so that she could kill her. Premeditation, deliberation. Now, admittedly, the defendant didn't kill Amie by injecting her with nicotine. That was his original plan. Now, just because he didn't kill her in the way he originally intended to kill her, doesn't mean that he didn't possess the intent to kill, that he didn't kill her with premeditation and deliberation. Now, it's okay that there's a different method of murder here. His intent was very clear. He carried the syringe into the home. He prepared for that murder with the way he was dressed, with his actions. Now, when Michael Herman yells, "Hey, motherfucker," he's essentially the one that thwarts the original plan. As you heard in evidence, she was beating up Amie. He was strangling her to the point of unconsciousness or a very weakened state. And when the defendant hears Michael Herman yell, "Hey, motherfucker," from these stairs, he reacts. He decides to pick up Amie and drop her over the balcony to her death, because he does this on purpose. He doesn't want her to live to be able to implicate him in any of his crimes. And then he immediately runs away. Now, I want to talk to you about the defendant's flight. And like Mr. Avila said, I'm going to echo this. His conduct, the defendant's conduct before, during, and after the murder speak volumes to his guilt. It speaks volumes to his intent. Now, if we're to assume from the defense that it was Amie that initially provoked him into this fight, and that she on her own went over this balcony, why is it that he just flees the scene? There's a jury instruction specifically to this point. If the defendant fled, that conduct may show that he was aware of his guilt. He runs outside the side door of the kitchen and out from which he came, which is the chain link fence, and we know that from ring videos. And in order to do that, he has to run just by Amie's body. It looks farther in the photograph, but as Mr. Avila talked about, it's very close. In order to jump that fence and go back to the neighbor's property, you're going to see Amie's body. So this man who allegedly loves her, is so desperate to talk to her, cares for her, runs by her lifeless body on the pavement. He doesn't go to render her aid. I mean, if he was just there to talk to her and she fell on her own, why run away? Why not go and help her and see if she's okay? Why not go talk to Michael Herman and explain yourself? Call 911, call an ambulance, call the police, do something. His decision was to run away and leave her to die. That goes to show his guilt. Something else that goes to show his guilt is that within 46 minutes of committing this murder, let's just say within an hour of committing this murder, he decides to reach out to a girl he met on a dating app, Natasha Paulson, to respond to a text message that she sent hours earlier. Ha ha ha, that's funny. I mean, the defendant's a cold-blooded murderer, right? You literally just took someone's life. Yet, the first thing you do within an hour of murdering that person, of watching her die, is to text some random woman that you just met on a dating app?
I object. Watching her die, that's... Oh, she was not dead.
The next morning, after the murder, what does he decide to do? At around 11 a.m., he texts Angela G, morning sunshine, what are you up to? And then proceeds to hang out with her for a few hours until she's arrested. Again, he's either trying to plan an alibi witness, or he really doesn't care about the well-being or welfare of Amie after dropping her over the balcony of her own home. That goes to show who the defendant is. A manipulative, selfish, callous murderer. His cell phone.
Let me ask you, counsel, how much more do you have?
Like 5 minutes.
Okay, go ahead.
His cell phone. The defendant cell phone is taken into the possession of local law enforcement, and they look for all these text messages that we see, this voicemail, all of that, and it's nowhere to be found. It's because the defendant purposefully deletes those text messages.
This was a subject.
It was just, suffice it to say, it was not on his phone.
I'm sorry?
Suffice it to say, it was not on his phone.
Correct.
Information, okay.
This information was not on his phone. And he's a smart guy. This was purposefully taken off of his phone.
Your Honor, same objection, strike.
We
It's
were
reasonable.
allowed to argue reasonable inferences.
Reasonable inferences, yes, but we had I think the court made a ruling with respect to that. So the court characterized what you could say on that.
Sure.
Yeah, so go
That
ahead.
information was nowhere to be found on his phone. But we know that those messages were sent, those calls were made, but they were nowhere on his phone. Where did they go? How did they disappear? Think about this jail visit that he had with his two friends, Corey and Eigen, as well.
So can you say you're not getting correct? Is that what you're trying to say? Yes. Okay. I've seen what's coming at me. Not good. I'm not gonna go.
Now, the tone of this jail visit has zero reference to Amy's, any sympathy for Amie. They don't talk about Amie at all. And in the one reference that they do, there's no sympathy there. He doesn't care about her well-being whatsoever. And despite all the excuses the defense tries to bring about the tone of this call, about him joking around, laughing, zero sympathy for the victim, those are all excuses Ms. Bernstein-Liv gives you. Excuses for the defendant's consistent bad behavior throughout this entire incident, including this jail call. He even says near the end of the call,
I guess I'm officially a bad boy now, right? I've always been kind of. No, you won that game. Yep. You're a bad boy now. I'm gonna have to change my Twitter handle to quasi bad boy.
he says, I guess I'm officially a bad boy, right? This jail call is just a glimpse of who the defendant really is, and that is a callous, cold-blooded murderer. He doesn't care about anybody but himself. He's manipulative and entitled. And defense tries to draw a parallel between the defense's use of humor in this call and Hernando Chavez's use of humor when he's interviewed by the police to deal with his grief. But there's a substantial difference between Hernando Chavez and the defendant, and that is Hernando Chavez did not kill Amie Harwick, and the defendant absolutely did. So it's totally inappropriate use of your humor. You've just been arrested for murdering someone you loved and cared about and couldn't get over for over a decade. And this is how you sound in a visit between you and your two friends? Last slide, Your Honor, I promise. Motive. The law states that having a motive may be a factor tending to show that the defendant is guilty. And the defendant absolutely had a motive here. In these text messages that he sends to Amie, they go completely unanswered. She answers once, setting those boundaries, saying she wants no contact with him, and she never responds to him after that. And that makes the defendant angry because she shut him out. She wanted absolutely nothing to do with him. And because she shut him out, he wanted to punish her. He wanted to punish her by killing her. Just take a look at that jail visit. Take into account how he murdered Amie. It was a brutal way to kill somebody and very personal. When you take that into account, it shows just how angry the defendant is. It shows the true glimpse into his motive, and that is he wanted Amie to suffer. Think about it. You saw the wounds to her head and her hands in defending herself. The defendant struck her in the face repeatedly, causing a nose fracture. Frankly, this was a beatdown. Let's just call it what it is. It was a beatdown. And then he strangled her to the point of unconsciousness, to the point of a weakened state, and it caused her to urinate all over herself. And then he threw her, or tossed her, dropped her over the balcony, plummeting to her death. And Amie screamed. Amie struggled. Amie fought for her life. Yet the defendant doled out his final punishment on Amie Harwick during that beatdown, during that strangulation. Instead of leaving her on the third story of her home, beaten and bruised, his final punishment was to pick up her body and drop her over that balcony. That was his true motive, to watch her suffer. And I ask you to hold the defendant responsible for his heinous actions, because he's a callous, selfish, entitled, and manipulative, cold-blooded murderer. So please find him guilty of the crimes of first-degree murder, burglary, and find true the special circumstance of lying in wait. Thank you.